Hello people, this is CA and I'm going to be talking about policing for profit. Now in policing for profit, that is basically what is given the term of what law enforcement taking away funds or taking away anything to do with criminal activity or what they deem as criminal without any type of proper procedures being followed. It is legal for them to do this, but that doesn't necessarily make it ethical in any way, shape, or form. But of course, when have police officers cared about ethics? So this is a review of the 2010 report that was titled Policing for Profit. Now, I'll go ahead and I'll start in regards to the forfeitures, where most states and federal law enforcement can keep some or all proceeds from civil asset forfeitures. This has led to concern that civil forfeiture encourages policing for profit as agencies pursue forfeitures to boost budgets over other policing priorities. Also, this makes the legal standard quite low in proving that a property was used in a crime, since it's lower than beyond a reasonable doubt for criminal convictions. Now, there's three different ones. I'll go into that later. But one thing that you should understand is that the innocent owner defense, many jurisdictions provide an innocent owner defense where owners bear the burden of establishing their innocence. So in effect, what this does is give property owners, say that property owners are effectively guilty until they are proven innocent of whatever property that they might hold. And there are even loopholes that federal law officials can abuse, such as equitable sharing, where state law enforcement can turn over seized assets to the federal government or seize assets jointly with federal officers. The property is then subject to federal law and not state law, which provides as much as 80% of the proceeds to state law enforcement and stacks the deck against property owners. Now, the extent of this forfeiture use, in regards to 2008, the DOJ held more than $1 billion in net assets, money forfeited from property owners and now available for federal law enforcement activities after deducting various expenses. So basically, they use these civil asset forfeitures to fund the raids that are going on to cause more forfeitures. Now, to put this in context, in 1986, the Asset Forfeiture Fund took in $93.7 million in deposits. And in just 9 states, from 2001 to 2002, the currency forfeitures, this is not, amounts or anything, but just money seized, total $70 million. So from 2007 and 2008, equitable sharing payments doubled from $200 million to $400 million. Now, how was this policing tested? There were 3 main things that were tested. The profit motive of most states, where it was found that most states with no profit motive received more in equitable sharing than agencies with 100% profit motive. And there was an increase of 25% of equitable sharing dollars. The innocent owner burden was tested, which was the presumed innocence for owners, which leads to an increase in equitable sharing of $27,600 per year for an average sized law enforcement agency. So that's an increase of 23%. And then there's the standard of proof. Now, the presumed innocence for owners, by raising the standard of proof by just 1 level, leads to an increase in equitable sharing payments of $16,860 per year, or an increase of 14%. Now, what are the results? You have 47 states that received C's or D's. There were 3 states in particular that received higher grades: Maine, North Dakota, and Vermont. Most state civil forfeiture laws provide little protection to property owners. 6 states received an F, and 29 states received a D for their laws alone. The federal government receives a D-. So in other words, they have no civil forfeiture laws that provide protection for property owners. And 8 states received a B or higher for their laws: Indiana, Maine, Maryland, Missouri, North Carolina, North Dakota, Ohio, and Vermont. The grades were pulled down by extensive use of equitable sharing. In other words, they take the money from the federal government, they share with the federal government funds it to them, nobody knows what's going on. The lowest graded states with poor laws and aggressive use of equitable sharing: Georgia, Michigan, Texas, Virginia, and West Virginia. Now, the public accountability is extremely limited. Only 29 states require law enforcement to collect and report forfeiture data, and only 19 responded to Freedom of Information requests. So in other words, they can take this money, there's no accountability, they can use it for whatever they want, and no one is the wiser. But how did we get here is the question that we want to know today. Criminal forfeiture requires that the government show that property is obtained illegally. Civil forfeiture is a legal fiction that enables law enforcement to take legal action against inanimate objects. They can take the cell phone for in-rem use. An alleged criminal activity regardless of whether the owner is charged with a crime. In-rem proceedings, the property itself is charged with a crime. Well, this phone was used in a crime. That's an in-rem proceeding. Civil proceedings do not afford property owners the same constitutional protections as afforded criminal defendants. But where did it start? Well, in-rem forfeiture began from medieval ideas to seize instruments of destruction, ships, cannons, whatever you have, from a superstitious belief that objects acted independently to cause death. Now, the British Navigation Acts were passes in the 17th century as a maritime power. So the U.S. used the British Navigation Acts as a model and passed forfeiture statutes to aid in collection of customs duties, and later upheld in earlier Scottish cases. And just as a history lesson, asset forfeiture was used during Prohibition against automobiles and other vehicles transporting illegal liquor. The civil asset forfeiture then exploded in the early 1980s as government at all levels stepped up the war on drugs, creating new incentives for the abuse of civil forfeiture. After the creation of the Asset Forfeiture Fund, law enforcement used the funds for purchasing vehicles as well as overtime pay. So in other words, what you should notice here is that law enforcement can get around any type of budget set by the state and find their own ways to do business. The Civil Asset Forfeiture Reform Act did not ameliorate the profit incentive law enforcement agencies have in civil forfeiture. So it didn't help make the situation any better. And this was passed in 2000. The civil forfeiture is not tied to difficulties of obtaining personal jurisdiction over an individual. So today we have over 400 federal forfeiture statutes relating to a number of federal crimes, and all states have statutory provisions for some form of asset forfeiture. And the CAF is only growing and being used more extensively now. Now, how do you evade the state law? As I said before, equitable sharing provides law enforcement a way to circumvent unfavorable state forfeiture procedures. Over 40% of police agencies report that civil forfeiture proceeds are a necessary budget supplement. In other words, proceeds represent an average of more than 14% of a law enforcement's budget. It's like a drug. They're addicted to it and they need more and more and more and more. And most agencies count on civil forfeiture proceeds by including it in their budget estimates. Now, what is this perverse incentive? This civil asset forfeiture creates an incentive for law enforcement to over-enforce certain statutes and neglect other duties. Look at the drug war. It's been going on since 1973 with controlled substances, and you have law enforcement going heavily for minorities totally perverting the drug war on drugs, and it's becoming a war on race, which also tends to lead to racial biases. You're going to go after more black people because guess what? They're more likely to have the drugs because they're being attacked for marijuana, even though there's plenty of resistance against that idea. That's just how it's been going. So you have all these people at the top trying to say, well, we want to fight the war on drugs by going after minorities. It's actually legal to do that. It just boggles the mind. But anyway, limited public oversight and accountability. Many states do not require law enforcement agencies to report how much money has been raised and on what items the money has been spent. So in 2003, only 29 states required this basic oversight, and only 19 states responded to Freedom of Information requests with reliable info, and those states had very limited data. Now, what are the abuses? If you think it's just, one or two things, be prepared to be amazed. Camden, Georgia, $90,000 was used for a Dodge Viper for the county's DARE program. $3 million, not one, not two, but $3 million was used to build a sheriff's substation. And $250,000 was donated to the sheriff's alma mater for a scholarship. In Webb County, Texas, $20,000 was used for TV commercials for a district attorney's re-election campaign. And in 1990, a United States Attorney General was quoted as saying, "We must significantly increase forfeiture production to reach our budget target. Failure to achieve the $470 million projection would expose the department's forfeiture program to criticism and undermine confidence in our budget predictions." Now, are there other abuses? Police supervisors are keenly aware of the financial benefit of engaging in forfeiture activities and frequently made operational decisions to maximize perceived financial rewards. The pursuit of profit clearly influenced policies on which cases they selected in court. Forfeiture and perverse incentives. One example, the reverse stings. Police pose as drug sellers rather than the buyers. This is used to target low-level non-trafficking drug offenders who are subject to less severe criminal penalties than those arrested for drug sales and do not affect drug supply. This actually targets the buyers rather than sellers because the buyers tend to have more cash on hand subject to forfeiture. And does it actually do anything to stop the war on drugs? I'll let you all decide. Now, let's go up to the top. How do the prosecutors profit from civil asset forfeiture? Well, the evidence shows that prosecutorial discretion has been inappropriately influenced by the presence of asset forfeiture options. And even current and former justice officials have acknowledged the power incentives of financial rewards from forfeiture. In essence, law enforcement has become a business where those that enforce the law want to hit the pocketbook of narcotics organizations. But those narcotics organizations make billions. So what about reform? All law lobbying has resisted reform to forfeiture reform efforts. Such law lobbying resisted the amendments to federal asset forfeiture laws that would have required the state proceeds from equitable sharing with federal government be subject to that state's laws. And they were repealed before they ever became effective. The standards of proof, just so you understand what each standard is. There's probable cause, which is the lowest standard for forfeiture in 14 states. It's reasonable belief that a person has committed a crime. Well, I can be committed with probable cause of almost anything. I could be with probable cause be told that I burnt this book in my earlier years. That's what probable cause is. Preponderance of evidence. It's higher than mere probable cause and equates to the idea that it's more likely than not that the property is related to criminal conduct and thus subject to forfeiture. Standard for federal government. So this is the most common. Basically, through the preponderance of evidence, you can say that I have this phone, I have this book, I transmitted a copy of this book through this phone, just on the preponderance of evidence. Now there is also clear and convincing, which is a greater challenge for government to prove its case, but it's less than reasonable doubt. And in case you thought this was too long, didn't want to watch it, in the vast majority of states and at the federal level, the standard of proof required to forfeit an individual's property is lower than the standard required to prove that the individual was guilty of the criminal activity that justified the forfeiture in the first place. 80% of forfeitures occur absent a prosecution. So what are the recommendations for reform? End the direct profit incentive under civil forfeiture laws. Impose a high standard of proof on law enforcement in civil forfeiture proceedings. Provide a meaningful defense for innocent owners by removing the burden on property owners to prove they're innocent and placing the burden of proof on the government. Require all agencies to track and report civil forfeiture revenue and distributions and make the info available to the public. And respect federalism principles by abolishing equitable sharing arrangements with the federal government. No more end runs around the procedures of a state to forfeit your property. To forfeit no more end runs around the procedures of a state to forfeit property. And that's the main thing that I had right now for policing for profit. I hope you found this enjoyable. I hope you enjoyed all the discussion, because this is actually very relevant in the domain seizures, as well as other parts of other cases where you see that the laws are being abused by police officers, especially given that we have over 4,500 different statutes. We do need some laws, but to believe that the government can actually do end runs around it and find and abuse laws, and no one is held culpable for this, that is the problem that we currently have. Take care. I'll have more later. See you next time.